Ariel's actions in leading the defendant on, no question, certainly less than ideal. But once again, I'd only ask that you look at those texts and you will see, and it's really too bad that we don't have the other side, because as I said, we know from Detective Kenny, there were, just based on a few random texts that he picks up, other things going on, communications during those time period. But even the ones you can see, even the one-sided texts that you can see that are out of context, you can see that often she's trying to get the defendant to respond to her. Okay, ignore me, fine, whatever the exact wording is, I don't have the text in front of me. When she's trying to get the defendant to respond, she knows there's one thing that he will respond to, and that is the thing that he has been pushing on her. Not that she wasn't biting to a certain extent. With the abortion, she said, I thought I could do it, then I realized I couldn't. And then later with the adoption, no question. But that being said, the focus is not on whether or not there were legitimate reasons for an adoption, but what he did on the day in question. I'd also like to suggest to you that Ariel, being portrayed in this courtroom, is the one who was interested in adoption. Well, that's interesting, but if you look at the defendant's computer and you compare it to what he told Sergeant Posma, oh yeah, adoption's Ariel's thing. I really have nothing to do with that. And then you've got counsel and him arguing, well, there were legitimate reasons for an adoption. Well, maybe so. But don't forget what the defendant told Sergeant Posma. Oh yeah, adoption, that's Ariel's thing. I don't have anything to do with that. She's some girl, just some girl that I dated briefly 3 years ago. And Catherine, it's not my daughter. What is on the defendant's computer is completely at odds with what he told Sergeant Posma. Counsel, once he digresses to the other side of the argument, okay, so if you do believe she's dead, well, then it was an accident, and the prosecutor hasn't proved that it didn't happen like he said in the letter. The letter speaks for itself. Ladies and gentlemen of the jury, if you read that letter, in just what the defendant admits to doing, it's second-degree murder. It's not involuntary manslaughter, and I'll trust you to look at the instructions. Defendant admits he was angry and he ripped the car seat out. This wasn't an accident. He did something overtly and intentionally. And don't forget, because counsel has said to you, the baby was unbuckled, the car seat was strapped in. Do you honestly believe he didn't know that baby was in the car seat? Even assuming it happened like he said, that he ripped the car seat out. He knew that baby was in the car seat. He was mad. It's the sequence in his own letter. I was mad, I ripped the car seat out, I'm sorry. That car seat was strapped in. And I would suggest to you that it is in no way, shape, or form a coincidence that he just happened to go off the grid for 2 hours during the critical time period, and that he threw Ariel's phone out in an area that he later told her in a letter, and she told you she went looking for it, she didn't find it. Something very sinister happened during that time frame, and counsel has said, I think I counted 4 times, he didn't plan this, he didn't plan this, he didn't plan this. You're not assessing this for first-degree murder. You're looking at second-degree murder. And second-degree murder is he intended to kill. There's no planning involved. Or intended to do great bodily harm, or intended to create a situation with a high risk of death or great bodily harm. Planning doesn't figure into it. The defendant has pointed out a number of different things to you and said, well, there's nothing wrong with having a diaper in the car. No. But when you add it together with everything else that you know about this case, the fact that her clothing was in his pocket, it all goes together. And then counsel says, well, they didn't test the diaper for DNA. And I ask you, ladies and gentlemen of the jury, what's DNA going to prove? That's Catherine's diaper. It matched the ones in the trunk, same floral print, same infant size. Of course, baby Kate's DNA is going to be on that diaper, and as you heard from the crime lab specialist, it doesn't prove anything, really. They did attempt to get a latent print off of it, and there were no prints. And as you heard from Sergeant Posma, it's not like CSI. You all indicated during jury selection that you understood that. You don't always get prints, and clearly if that diaper is in the back seat of a car, somebody touched it. So the fact that his prints on it are not on it really don't mean anything. But when you look at the evidence in its totality, the fact that her clothes are in his pocket, and then you couple that with the vehicle he was in with the baby that disappeared for 2 hours, and the baby was never seen again, and there happened to be a diaper, then I would suggest to you, ladies and gentlemen of the jury, there really is significance to that matter, to that point of evidence. If the defendant really had the great relationship he wants you to believe with Ariel, then why did he describe her the way he did to Sergeant Posma? He also talked to you about Rashawn Burton, and, well, he couldn't, what he said happened couldn't have happened because he was in segregation. You didn't hear any evidence about how the segregation works in regards to the library. Rashawn Burton told you, I'm up here, I don't have a dog in this game, but he's told me something about a baby. I didn't get any deals, and he was unequivocal, and you didn't hear that he did. Not a single deal. To come all the way up from Georgia during a hurricane to testify, because he knows that what the defendant told him was something significant, and that is that a woman was trying to pin a baby on him, but he got rid of the baby, and he'd never be charged. And really, if you look at Rashawn Burton, I mean, throw him out if you will. The letter alone is enough for second-degree murder, but throw Rashawn Burton out if you will. But what's interesting about Rashawn Burton's testimony is, you look at the fact pattern that we know exists, the defendant's clothes, Catherine's clothes in the defendant's pocket. He was trying to do something there. So what Rashawn Burton actually says has significance when you couple it with the fact that we know baby Kate's clothes were in his pocket. I got rid of the baby, and nobody will ever find the baby, so I can never be charged. He was thinking already. And while I'm on that subject, counsel has thrown out a number of things. Well, this is consistent with the defendant being panicked. Maybe he was afterwards, I don't know. It doesn't negate what he had already done. But a panicked individual doesn't stop and buy fireworks and show them off to his mother. You heard from Abraham Hernandez. He was talking about the National Guard. He was there about 20 minutes. That is a cold and detached individual. And all the evidence you've heard in this courtroom pretty much proves Ariel told you, I thought he was accepting the baby. And there's no question in this courtroom that Ariel's perception of the relationship was always much more positive than the defendant's. But Ariel's hopes and perhaps delusions that he was accepting the baby really are not consistent with all the evidence that you've heard in this courtroom. The fact that he got mad when he got served with paternity papers, the fact that he was somewhat pressuring her, not that she wasn't involved in abortion, then adoption, the fact that this happened on the day when things reached critical mass, the fact that the defendant in his own letter admits how angry he was that day, angry for that day, for everything, maybe ever, the fact that the defendant admits doing something in anger. Those are not the actions of a scared person, they're the actions of a mad person. And second-degree murder only requires that he created a situation with a high risk of death or great bodily harm. And there can be no question that ripping a buckled car seat out when you know a baby's in it, and we all know he knew the baby was in that car seat, that is a situation with a high risk of death or great bodily harm. Ladies and gentlemen of the jury, I could belabor a lot of points here. I'm going to say this. I was in the same courtroom with counsel, and you were in here too. And many of the things that he said, I certainly don't remember from testimony, or don't remember them quite like he said them. I'm going to rely on your collective memories, the 12 of you that go into the jury room. But I'm also going to ask you to use your common sense and put the pieces of the puzzle together. What makes sense and what doesn't. Because every iota of evidence that you have heard in this case points in one direction and one direction only. You don't just take off with the baby and come back 2 hours later with no explanation and say, well, it was innocent because I turned off my phone because Ariel was blowing it up. You bet she was blowing it up. He just took off with baby Kate. And so, okay, that's an innocent explanation. There is no explanation for going off the grid for 2 hours and returning without the baby. And that's before you ever get to the letter that he wrote. And once again, as I told you in my initial closing, that's the minimum bar. He's admitting to second-degree murder in that letter. But that's the minimum bar of what he's admitting to. I would suggest to you it's probably much worse than that. Ladies and gentlemen of the jury, I could belabor a lot of points. Like I said, I'm going to rely on your collective memory because I don't want to sit here and say, well, Mr. Glancy's wrong about this and this and this and this. You've heard what I have to say in my original closing argument, and you've heard what Mr. Glancy has to say. Use your reason and common sense. Ladies and gentlemen of the jury, nobody owns life. But anybody who inflicts violence on a 4-month-old infant owns death. Might I suggest to you that in this circumstance, the defendant owned death for baby Kate. I ask for the verdict that in your hearts, in your minds, and in your souls, you know to be the true one, because he knew too. He knew what he was doing when he left Wendy's, even if he was still mad when he left Ariel's apartment. He knew what he was doing when he opened the car door to the back seat and saw baby Catherine in that car seat, strapped in car seat, even if she was unbuckled. He knew what he was doing when he ripped that car seat out. And as he sits here today, he knows what he did. And now you do too.
Ladies and gentlemen of the jury, you've been provided with a written copy of the final jury instructions. When you go to the jury room, you should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, turn off your cell phones and other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and to make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. In this case, there are several different crimes you may consider. When you discuss the case, you must consider the crime of second-degree murder first. If you all agree that the defendant is guilty of that crime, you may stop your discussions and return your verdict. If you believe the defendant is not guilty of second-degree murder, or if you cannot agree about that crime, you should consider the less serious crime of involuntary manslaughter. You decide how long to spend on second-degree murder before discussing involuntary manslaughter. You can go back to second-degree murder after discussing involuntary manslaughter if you want to. If you have any questions about the jury instructions before you begin deliberation, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. Possible penalty should not influence your decision. It's the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal to anyone As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions and any or all of the reference documents or exhibits that have been admitted. Just ask for them. You have been given a written copy of the preliminary instructions and of the final instructions. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the crime of second-degree murder or guilty of the crime of involuntary manslaughter or not guilty. I have prepared a verdict form listing the possible verdicts. Do you have any questions about these instructions? I see none. Now, what we do now, ladies and gentlemen, is we select two of you who will not participate in deliberations, but will be kept in reserve in case there's any reason. By way of example, if somebody fell ill or was involved in an accident, then we would have to bring the extra two jurors in for purposes of deliberation. So 12 will go to the jury room. 2 will go to another room that will take you where you sit without discussing the case and without listening to any news reports or discussing with each other or anyone else anything about the case. Those in the 2 that are in the second room may read, you may get something to read, but you will not be participating in deliberations. And I'm going to ask the bailiff to draw those 2 names. Thank you. Okay, juror number 10 and juror number 12 will, that will be Mr. Krieg and Mr. Lutz. Now, before you leave, I need to bailiff, raise your right hand. Do you solemnly swear that you will, to the best of your ability, keep the persons sworn as jurors in this trial from separating from each other? That you will not permit any communication to be made to them or to any of them, orally or otherwise? That you will not communicate with them or with any of them, orally or otherwise, except upon order of the court, or to ask them if they have agreed upon a verdict until they shall be discharged? And that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon?
I will.
All right. Now, Mr. Luce and Mr. Krieg, if you would accompany bailiff, he will take you to a room where you will be able to be, if you need something to read, we'll accommodate you. With respect to the other 10 jurors, you go to the jury room.
12.
12, excuse me, my apologies. The other 12 jurors go to the jury room, select a 4-person, have the 4-person knock on the door. Bailiff will hand you the verdict form and any envelopes in case you need to ask any questions. Once again, are there any questions from the jurors? Okay.
And I might get my stuff
You
out
may.
here.
Yes, you can go grab your personal articles. All right, and you will go out that door with the bailiff. That second bailiff, and you will take custody of the primary custody of the court.
Yes, sir.
All right. Get seated. All right, counsel, are there any objections to the jury instructions read by the court?
No, Your Honor.
No.
All right, with that, everybody is going to go into recess, and you need to stay close. There may be questions. There probably will be a request for the exhibits, and we'll send those in. But to the extent that we have those questions or requests for exhibits, I will need you to be available to discuss any issues that may come up. So we stand in recess until we hear more from the jury.
Thank you, Your Honor.